All rise. Vous vous levez. Please be seated. Vous vous asseoir.
Thank you. We will continue with the submissions of the legal representatives of victims. And now it's time for LRV 2. I understand that you decide to share your time allocated to you for 3 parts. And as the first, Ms. Gallagher, you have 10 minutes according to your internal agreements. Please proceed.
Good morning. Thank you, Your Honors. It is my privilege to appear today as legal representative for Sharkawi El-Haj and Khalid Hassan Duran. Mr. El-Haj and Mr. Duran are currently detained at the U.S. Naval Detention Center at Guantanamo Bay, where they have been held without charge since August 2004 and September 2006, respectively, after being detained by or at the direction of the United States on the territory of a number of ICC member states, including Afghanistan. Because of their ongoing detention at Guantanamo, the victims have not been able to assist in the preparation of these submissions to the court. As you have noted, the 3 legal teams under LRV 2 will be equally splitting the time to address questions in Group A and B. In the limited time available to me this morning, I will set out a frame through which victims' arguments on standing and jurisdiction, as well as tomorrow's arguments on the merits, must be understood. My focus is limited to the third dimension of the requested investigation in the situation of Afghanistan, namely the investigation of U.S. actors for torture and related crimes. Like the other legal representatives in today's appeal, I submitted victims' representation forms for both men in January 2018, which I supplemented with a 55-page factual and legal analysis that was transmitted to the pretrial chamber. That's ICC 02-17-38, Annex 1. Both Mr. El-Haj and Mr. Duran expressed their full and unqualified support for the opening of an investigation into what they assert are extremely grave criminal acts by U.S. actors arising out of the operation of a global network of prisons by the CIA and the U.S. Department of Defense, including on the territory of Afghanistan and other states parties, namely Poland, Lithuania, and Romania. The network of prisons began in 2002 and thus coincided with the activation of ICC jurisdiction. Torture and other forms of cruel treatment, including widespread acts of sexual violence, were part and parcel of the U.S. rendition, detention, and interrogation program from the moment of, quote, capture or kidnapping and continuing through one's detention. Both Mr. El-Haj and Mr. Duran are discussed in the U.S. Senate Select Committee on Intelligence's Executive Summary on the CIA Detention and Interrogation Program, commonly known as the Senate Torture Report, which was released 5 years ago next week. The harms they suffered and continue to suffer are not, however, unique to them. They are a result of a planned and organized policy that caused widespread and systematic harms to many other individuals secretly transported around the globe, often through member states, airports, and airspace, for detention without charge by the DoD and the CIA. Afghanistan, with both DoD and CIA detention centers on its territory, was the epicenter of the U.S. torture program. I detailed for the pretrial chamber why these acts warrant a full-fledged investigation into war crimes and crimes against humanity by senior U.S. officials. As the pretrial chamber correctly found, under 3 successive administrations, the United States has been wholly unwilling to properly investigate, let alone prosecute, those U.S. senior officials who ordered, authorized, and furthered the torture program. Unless there be confusion, it is indeed those who bear the greatest responsibility for the torture program, the U.S. civilian and military leadership, as well as CIA contractors, who the ICC should investigate, not the foot soldiers nor the many facilitators, regardless of how integral their criminal contributions might have been. As was conveyed to the pretrial chamber in victims' representations, the opening of an investigation into the U.S. torture program would make clear that no one is above the law, regardless of power or position, that those who bear the greatest responsibility for serious international crimes will be held to account and will not enjoy global impunity, and that all victims of serious crimes deserve to and can have their claims heard and adjudicated by an independent and impartial tribunal. Unfortunately, the reality has proven to be the opposite. As is well documented, after the prosecutor sought authorization to open an investigation into the situation of Afghanistan, senior members of the current U.S. administration, including the president himself, launched an attack against the ICC that included the threat of sanctions against the institution, the prosecution of its officials, and saw the U.S. visa for the prosecutor revoked. Nearly 16 months after receiving the prosecutor's request, which is more than 4 times the length of consideration of any former Article 15 request, in a decision that was conspicuously light on precedent or support, the pretrial chamber denied the investigation. This came less than 2 weeks after the U.S. revoked Prosecutor Bensouda's visa. Whether the two events are in fact related is unknown, but for many victims as well as commentators, the timing appeared more than coincidental. Indeed, the U.S. Secretary of State issued a statement following the pretrial chamber's decision, in which he explicitly credited the U.S. campaign against the court for the ensuing rejection of the investigation request. The victims do appreciate that in the face of such threats and action by the United States, the prosecutor sought to appeal the decision and appears to continue, at least for now, to seek authorization to open all 3 dimensions of the investigation. Respectfully, however, the prosecution cannot capture the full import of the denial of the investigation on victims. The victims saw their calls for justice not only unanswered, but disregarded. As will be addressed tomorrow, victims' submissions on the scope of the investigation, as well as their unqualified support for the investigation, were wholly ignored in the pretrial chamber's final assessment. Fundamental errors of law regarding the nexus required to an armed conflict by the pretrial chamber appear to have written my clients out of any investigation. With growing despair over his indefinite detention and little prospect for accountability and redress, Mr. El-Haj tried to commit suicide in August. In recent weeks, it has been reported that the current U.S. president, who promised during his campaign to, quote, bring back a hell of a lot worse than waterboarding, selected the current head of the CIA, Gina Haspel, not despite her history of running a CIA black site where individuals were tortured, but because of this experience. War criminals have been pardoned against the advice of military leadership. Reoccurrence is the price paid for impunity. And impunity for those deemed too powerful to prosecute sends a message to leaders, dictators, would-be genocidaires everywhere, that they too can get away with it. Finally, a few brief remarks on standing and jurisdiction on behalf of Mr. El-Hajj and Mr. Duran before Ms. Hurst and Ms. Reich address these issues in more detail. With regard to standing, victims El-Hajj and Duran submit that their standing to appeal stems from the exercise of their unqualified and statutorily recognized procedural and substantive rights granted to them in Article 15 proceedings. The pretrial's failure to engage at all with the substance of their representations, including in regards to interests of justice, and the direct negative impact on their fundamental rights and interests resulting from the denial of the authorization. They endorse the three factors put forward by the Afghan victims, which, at a minimum, posit that victims who made representations are entitled to appeal a decision pursuant to Article 15.4 when that authorization has been denied. With regard to jurisdiction, victims El-Hajj and Duran fully endorse the conclusion that will be elaborated upon by Ms. Reich. The decision is one with regard to jurisdiction under 82(1)(a) because it divests the prosecution of the power to exercise investigative jurisdiction as set forth in Articles 15 and 53 of the statute, and both because the specific errors regarding the scope and nexus, and because the disposition, the ruling, the denial of the prosecutor's request to investigate places conduct which squarely falls within the temporal, territorial, and subject matter jurisdiction of the ICC as set forth in the Rome Statute beyond the reach of the court. Thank you.
Counsel, the time is 10 minutes is up. Of course, it's up
But
to
thank
you.
you, and I stand ready to address questions later today.
Thanks.
Your Honours, I will address some core points relating to victims' standing and then turn to the first three of the Chamber's Group A questions. I will not be addressing question D in that section. It will be covered by Mr. Piechak, and we agree with the submissions which he will make. On the question of victims' standing, the provision which must be construed is Article 82, paragraph 1, and in particular the words either party. The question, for your honours, is whether victims can ever fall within that phrase. The difficulty appears to be that it has now become received wisdom in this court that victims can never be described as a party to proceedings. And yet, the statute says this nowhere. The rules say this nowhere. And in fact, it has become normal at this court for victims to take some procedural steps which the statute or the rules reserve for parties. In our filing of 19 June, which is document number 50 in this case, we gave the example of Articles 64 and 69, which relate to the conduct of trial and the submission and challenging of evidence. But elsewhere in the text, other examples can be found where the word party is clearly intended, we say, to encompass victims. For example, Article 70, paragraph 1b, creates an offence where a party knowingly presents false evidence. Surely there can be no dispute that the term party in this context includes participating victims and their lawyers. Your Honours, we say it cannot be right that the term party includes victims where it imposes obligations, but can never include them where it grants standing. In the specific context of Article 82, paragraph 1 appeals, the ICC case law already demonstrates that the word party is not limited to the prosecution and defence. As already mentioned by Mr. Gaynor, the al-Bashir case allowed a state party, Jordan, to appeal pursuant to Article 82, paragraph 1. In the present proceedings, the prosecution has made submissions about the risk of genies being let out of bottles, leading to proceedings which are overwhelmed by interveners, including states. And yet, in the Bashir case, the prosecution made no objection to Jordan's standing to appeal under Article 82, paragraph 1. In paragraph 39 of their response to the victims' appeal briefs, the prosecution accepts that states can be parties with standing to appeal, where this is, quote, consistent with the broader procedural scheme of the statute. But they say that this approach is applicable only to states. No reason is given as to why victim standing is not likewise to be assessed in a manner, quote, consistent with the broader procedural scheme of the statute. With this submission, the prosecution implies, incredibly, that the Rome Statute intends to give a greater voice to states than it gives to victims. The Jordan referral appeal also shows that no weight can be put on the word either in Article 82, para 1. In that case, the proceedings included the prosecution and the defence, and the chamber effectively recognised what is already clear from the language of the rules, namely proceedings can include more than two parties with standing to appeal. All of this serves to show, Your Honours, that there is no magic in the words either party. The meaning of those words must be established based on their context and on the statute's object and purpose. And this was the approach taken by the appeals chamber in the Lubanga case, when it held that victims can lead evidence and challenge the admissibility of evidence, despite the fact that the relevant provisions in the statute refer to parties. That's decision 1432 in the Lubanga case. The chamber held that Article 69, which refers to parties, must be understood in context, namely, together with Article 68.3, which envisages a role for victims at any stage of the proceedings considered by a chamber to be appropriate. That's paragraph 98. And the chamber went on to interpret the relevant provisions in light of the spirit and intention of the statute, which it said is for victims to have a role which is meaningful and not ineffectual. And Your Honours, this goes back to Mr. Gaynor's point regarding the need to interpret the statute purposively, and it demonstrates not only that this should be done, but that it has already been done by this court in respect of victims' role. In the present instance, there is a further crucial piece of context in addition to those which existed in the Lubanga appeal. And that is that Article 15 proceedings are the gateway to every form of participation at this court, as Mr. Gaynor has already explained. Your Honours, the prosecution says that recognising victims' standing would have disastrous consequences for the conduct of proceedings. Mr. Gaynor has already responded to the suggestions made about the risk of a flood of appeals. We will add one additional point, and that is to say that the prosecution's concern about the risk of parallel proceedings being launched by different participants, different parties in a proceeding, that concern is not specific and has no relation to the question of victims' standing as such. The possibility for parallel appeal proceedings to be initiated exists even in a proceeding which only involves the prosecution and the defence. Both would be able to appeal a decision, and it would be possible that one would use paragraph D of Article 82.1 and one would use another legal basis. I turn now to the Chamber's questions, on which we make 2 points. Regarding question A, we agree with the 3 factors which Mr. Gaynor identified. These are relevant in deciding whether victims can appeal in a given instance. One of those factors is the stage of proceedings and the role which victims are given at that stage. This will be a particularly compelling factor in Article 15 proceedings, given the role that Article 15 proceedings play in determining whether any further subsequent proceedings can occur at the court. So we don't rule out the possibility of victims standing in other phases, but we say there is no clearer example of a decision which fundamentally affects victim interests than an Article 15.4 decision. Some brief comments on the relationship between appellate standing and standing at first instance,
Counsel, you have 2 minutes left.
which is the question raised by both questions B and C in Group A. And the prosecution has today submitted that one of the reasons that they say the prosecutor only can appeal in Article 15 proceedings is because only the prosecutor can initiate such proceedings. However, standing to appeal is not limited to parties who could have initiated proceedings at first instance. No such limitation is found in comparative law. No such limitation is found in the statute or the rules. To give one very clear example, only the prosecutor can request an arrest warrant. Nobody contests that the defence may appeal a decision which issues one. The Jordan referral appeal provides another example. A state party cannot initiate Article 70 proceedings. Nonetheless, a state party was permitted to appeal the resulting referral. This is not to say that first instance standing rights are irrelevant, rather to say that the role of a party at first instance is one factor which can be considered in determining whether that party subsequently has rights of appeal, as explained by Mr. Gaynor. Your Honours, the creators of this court intended to lead the way in giving victims a real voice in international criminal proceedings. Since then, 2 international criminal courts, the STL and the ECCC, have recognised that this real voice entails allowing victims a right to appeal in some circumstances at least. This court is now in danger of falling behind. Your Honours have a chance now to correct that and to ensure that just as the drafters intended, victims can be heard on the issues which matter most to them. Thank you.
Thank you, Mr. Hirst. And then we have Mrs. Reich, who will conclude the submissions of LLV 2. Please proceed.
Thank you. Good morning again, Mr. President, Your Honors. It is a great privilege to appear before you today. As my colleagues indicated, I will focus my remarks on your Group B questions. Before I do so, I would like to tell you briefly about our client, Mohammed Abdullah Salah al-Assad, a victim of the U.S. torture program, whom we represent by and through his surviving family, and on whose behalf my colleagues and I appear today. Our client is one of many victims of the Coordinated Global Torture and Extraordinary Rendition Program run by the United States, with a hub, or as Ms. Gallagher said, its epicenter in Afghanistan, which targeted individuals suspected, often wrongfully, as in the case of our client, of ties to al-Qaeda, the Taliban, or other groups. Our client's horrific experience of torture and secret incommunicado detention is emblematic of why this calculated systematic abuse should be the subject of a criminal investigation by this court. In December 2003, Mr. al-Assad, a Yemeni national and successful businessman living in Tanzania, was seized from his home in front of his family by Tanzanian officials and secretly flown to Djibouti. Djibouti, a state party to the Rome Statute, held our client incommunicado for 2 weeks in one of their local facilities, where he was interrogated by an American official and threatened with death. He was then handed over to U.S. custody on the airport tarmac, where he was subjected to capture shock, a brutal procedure constituting torture that was systematically deployed by the CIA to foster what it termed learned helplessness, a sense of total subjection to U.S. control. Mr. al-Assad was stripped naked, sexually assaulted, diapered, chained, and strapped down to the floor of an airplane. He was then flown to Afghanistan, where he was held incommunicado in 3 different facilities. While there, his American captors subjected him to sensory deprivation and dietary manipulation, shackled him in painful positions, prevented him from sleeping, held him in isolation, and blocked him from sunlight. After a year and a half, he was released to Yemeni custody. Since then, Mr. al-Assad and his family have tried in vain to seek justice. Tragically, Mr. al-Assad passed away 3 years ago. Our client's surviving family, like many of the victims represented here today, has turned to the ICC as a last resort after unsuccessfully seeking accountability through numerous channels for more than a dozen years. The pretrial chamber's decision shuts the door of this court on our client and other victims similarly situated by erroneously finding that the crimes which they suffered fall outside of the court's jurisdiction and by completely foreclosing any investigation, let alone prosecution. Turning now to your questions, all of which we answer in the affirmative, the LRVs submit that the impugned decision is unequivocally a decision with respect to jurisdiction within the meaning of Article 82(1)(a). The impugned decision satisfies the standard articulated in this chamber's 2011 decision in the Kenya appeal because the pretrial chamber, as Mr. Gaynor said, issued a ruling specifically on the jurisdiction of the court. First, it is axiomatic that a decision that denies authorization to exercise jurisdiction is by nature a decision with respect to jurisdiction. An Article 15(4) decision determines whether the prosecutor may exercise jurisdiction pursuant to Article 13(c), and if so, confirms the scope of that exercise. In no way can such a decision be said to have merely an indirect or tangential link to jurisdiction. Second, here, the pretrial chamber made express jurisdictional findings, which it set out under headings of jurisdiction rationae loci and rationae materiae.
Excuse me, Counsel, please slow down a little.
Thank you, excuse me.
Thank you.
These findings are unequivocally jurisdictional. As Mr. Gaynor mentioned, they erroneously and prematurely exclude from the court's jurisdiction certain categories of crimes and victims encompassed by the prosecutor's request based on concepts set out in Articles 5 and 12 of the statute. For example, in paragraph 55 of the decision, the pretrial chamber states in no uncertain terms, and I quote, "The alleged war crimes whose victims were captured outside Afghanistan fall out of the court's jurisdiction," end quote. This ruling placed many of the crimes committed against victims of the U.S. torture program represented by the LRVs outside any investigation or eventual prosecution. These specific jurisdictional findings are not merely dicta or unrelated to the operative part of the decision. As Mr. Guarilla said, they were necessary steps to reach the analysis of the interests of justice, but they were not merely steps. As even the prosecution acknowledges, they materially affected and are inextricably linked to the pretrial chamber's understanding of the scope of the investigation and its subsequent appreciation of whether that investigation would serve the interest of justice. The operative part of a decision and its nature are defined by the substance of the issue determined, not the chamber's subjective characterization of its disposition. Here, the substance of the decision, and indeed of the interest of justice analysis, is the refusal to authorize the prosecutor's exercise of jurisdiction under Article 13(c), despite having found the relevant requirements were met as regards to both jurisdiction and admissibility. Moreover, if this chamber were to reverse or vacate the pretrial chamber's interests of justice analysis, as all appellants argue it should, these erroneous determinations with respect to jurisdiction would stand unless corrected. Concluding that the decision was one with respect to jurisdiction is entirely consistent with prior jurisprudence of this chamber. First, the decision is fundamentally different in nature from other decisions that this chamber has held to be too indirectly or tangentially linked to admissibility or jurisdiction. As elaborated in footnote 68 of our September 30th appeal brief, those other decisions involved matters falling outside of Part 2 of the statute, ranging from a state's request for assistance in its investigation to the postponement of surrender and the court's competency to release witnesses. The impugned decision here, which rules on the permitted scope of the investigation and excludes per se certain alleged criminal conduct and categories of victims, is more like, we submit, the 26 October 2011 Mbarashumana and the 22nd March 2016 Ntaganda appeals. In those appeals, this chamber recognized as jurisdictional in nature a decision regarding the scope of a situation referred to the court by a state party, an issue that goes to the exercise of jurisdiction under Article 13, and a decision regarding the exclusion of categories of acts and victims from the ambit of the court or its subject matter jurisdiction. The 6 November 2015 Comoros appeal decision does not require a contrary result here for several reasons. First,
You have 2 minutes left.
thank you. First, by its plain language, the decision appealed in Comoros only requested that the prosecutor reconsider whether there was a reasonable basis to open an investigation. It did not make any determination about jurisdiction or admissibility. Second, in evaluating the nature of the decision at issue in Comoros, the appeals chamber looked to the power that the pretrial chamber exercised under the statute. Doing so highlights the difference between that decision and the decision at issue here. Under Article 53A, a pretrial chamber is limited to requesting that the prosecutor reconsider her decision. It does not have authority to make its own decision. In contrast, under 15.4, the pretrial chamber is expressly mandated to decide whether to grant authorization. Third, the pretrial chamber decision at issue in the Comoros appeal was explicitly not the last word on the matter. It was a request to the prosecutor to take further action. In contrast, the decision here purports to be final as to whether or not the prosecution may exercise jurisdiction to investigate the facts put forward in its request. Article 15.5 does not change that. A subsequent request under Article 15.5, based on new facts or evidence, would be an entirely new and separate request from that which the pretrial chamber disposed of. Moreover, the prosecutor has expressly said in paragraph 18 of her October 22nd response to victims' appeal briefs, quote, if the pretrial chamber had ruled certain matters to be out of the court's jurisdiction, then it would manifestly not be proper for the prosecutor to return to that same chamber with those same matters. That is precisely what the pretrial chamber did here with respect to crimes committed against our clients and others who were captured outside of Afghanistan. Finally,
excuse me, counsel, to interrupt you. Please conclude. Your time is up.
Thank you. With Mr. President's permission, I'm concluding on your final question, turning to question C. The pretrial chamber's limitation of the scope of the investigation is a decision with respect to jurisdiction. Confining the investigation to only those incidents specifically included in the prosecutor's request and incidents closely linked to them not only defeats the very purpose of an investigation, but also places criminal conduct which squarely falls under the statute beyond the reach of the prosecutor and, by extension, the court. Circumscribing the prosecutor's investigative jurisdiction in this way is most certainly a decision with respect to jurisdiction and thus appealable under Article 82(1)(a). Thank you.
Thank you very much, counsel. This concludes submissions of LV Group 2, and then we'll proceed with submissions of LV Group 3. And there are 2 speakers announced. Please proceed. It, of course, is up to you. How
Thank
do you
you.
share the time allocated to LV 3? Scalander, please.
Thank you. Mr. President, Your Honors, I will begin talking about the facts involving our client, and then Mr. Piaczek will continue. I met Abrahim El-Nasri in 2008 in Guantanamo Bay Prison. I was his first lawyer and the first to visit him since his capture 6 years earlier in 2002. On that initial visit, he told me about the torture he had received. I was shocked. But everything he says is classified, so I could not repeat it, not even his memories. When we finally received the 500-page executive summary of the Senate Armed Services Committee report many years later, I was able to tell some of it publicly. I still cannot and will not confirm or deny where he was because my country has kept the names of those countries classified. Therefore, and because I have a security clearance, I must maintain that. I will use the code names for the countries, and I can only discuss the torture that the U.S. has already disclosed. But that torture that I can tell you here today is horrendous. From the beginning in 2002, when Mr. al-Nashri was seized in Dubai, he was not allowed to sleep, was regularly beaten, and hung by his hands. After 1 month, he was transferred to CIA custody and taken to a location codenamed Cobalt. In transit to Cobalt, ice was put down his shirt to use the travel time to induce anxiety and hopelessness. The torture began with the forced kidnapping and the utter terror of not knowing where he was going or what would happen next. Virtually no documentation exists of Mr. Nashiri's time in Cobalt. However, we know that it operated in total darkness and the guards wore headlamps. The prisoners were subjected to loud, continuous noise, total isolation, and dietary manipulation. The prison was essentially a dungeon. According to one CIA interrogator whose statements have been declassified, the prisoners at Cobalt, and I quote, literally looked like dogs that had been kennelled. When doors to their cells were opened, they cowered. The prisoners were fed on an alternating schedule, 1 meal one day, 2 meals another day. They were kept naked, shackled to the wall, and given buckets for their waste. On one occasion, Mr. Nashiri was forced to keep his hands on the wall and not given food for 3 days. To induce sleep deprivation, the prisoners were shackled to a bar in the ceiling, forcing them to stand with their arms above their heads. One of the interrogation methods was water dousing, where prisoners doused with cold water, rolled in a carpet, then soaked in water to induce suffocation. According to what Mr. Nashiri has said that is public, he was kept continually naked and the temperature was kept, in his words, as cold as ice cream. But that was not enough. Again, he was shackled, hooded, and taken on another airplane, adding to his fear and uncertainty and increasing what the government wanted was his helplessness. In his next prison, codenamed Cat's Eye, we know that Mr. Nashiri was waterboarded. As far as we know, only 3 prisoners were waterboarded. The current CIA head, Gina Haspel, destroyed all the tapes of the torture at Cat's Eye. Being waterboarded involves being tied to a slanted table with his feet elevated. A rag was placed over his forehead and eyes, water poured into his mouth and nose, inducing choking and water aspiration. The rag was then lowered, suffocating him with water still in his throat and sinuses. Eventually, the rag was lifted, allowing him to take 3 or 4 breaths, and then the procedure began again. To prevent his untimely death, a doctor was ordered to be in attendance to resuscitate him if necessary. But that too was not enough. Suddenly, without warning, he was again shackled, hooded, and transported to his next place of detention, codenamed Blue. There, he was kept continuously hooded, shackled, and naked. He was regularly strung up on the wall overnight, forced into stress positions, prompting a physician's assistant to express concerns that his arms might be dislocated. The CIA headquarters sent an untrained, unqualified, uncertified, an unapproved officer to be his next interrogator. This unqualified interrogator menaced Mr. El-Nashri with a handgun by racking the handgun, in other words, chambering a bullet, close to his head while he remained hooded. He also threatened to, quote, "get your mother in there," in an Arabic dialect, implying that he was from a country which was common to rape family members in front of prisoners. These threats were coupled with forced bathing with a wire brush to abrade his skin. There's also evidence that Mr. Nashiri was in fact forcibly sodomized, possibly under the pretext of a cavity search. Although the government of the United States later admitted that some of this unqualified interrogator's methods were improper, he was never prosecuted. Mr. Al-Nashri was later transferred under the same horrifying conditions to the prison code named Bright Light, or Black. There he was held in a prison basement composed of 6 prefabricated cells on springs to keep him and the other prisoners slightly off balance and to disorient him. During his stay in Bright Light, he was subjected to torture similar to the scheme in Blue. In addition, he was subjected to prolonged stress standing positions, including his hands being shackled to the ceiling for up to 3 days. He was confined in a very small box where he had to stand for several hours and then beaten by the use of the walling technique. The walling technique involves putting a towel around his neck, and while he is hooded so he doesn't know when it will happen, suddenly swinging him into a wall that has been fabricated to be flexible. Throughout the detention, he was also exposed to continuous sleep deprivation, cold, and forced nudity. He was transported to yet another country, codenamed Violet. Little is known about the specific conditions or ill treatment there or at the other prisons where he was held during this time. However, at a minimum, we know that Mr. El-Nashri was held in isolation, and by that time had suffered severe psychological and physical ill treatment after having been imprisoned for over 3 years, loaded into numerous airplanes, transported like a package, bound and hooded. Even animals are not transported in these conditions. And now we know that not one shred of actionable intelligence was learned from the torture and interrogation of any of the prisoners held in the black sites all over the world. Not one piece of actionable intelligence. No one from any country ever stepped in to stop the torture. No country has investigated what happened or sought to prosecute anyone involved in or knowing about the torture. No country stepped in to stop Mr. El-Nashri from being transported to the Guantanamo Bay prison, where Mr. El-Nashri is still held in solitary confinement and has yet to have a trial, now almost 18 years later. Yet the torture, imprisonment, and deprivation of rights continues to this day. He has been charged with numerous crimes. He was first charged in 2008. He faces the death penalty if he is convicted. In many ways, his torture has not ever ended. Thank you. I will now turn this over to Mr. Piaczek to continue our argument.
Thank you very much, Rolanda. Let's understand. Mr. Piaczak, you have still 15 minutes to address the court. Please proceed.
Thank you, Mr. President. Your Honors, it is demonstrative of the obstacles that Mr. Al-Nashiri faces in seeking justice that my esteemed colleague, Ms. Nancy Hollander, is forbidden by her own government to say the names of these countries in which he was detained, even after they have been expressly named in European Court of Human Rights judgments and many public reports. These detention facilities, sometimes referred to as black sites, operated with the acquiescence and secret connivance of these states which Ms. Hollander cannot name. In these black sites, prisoners suspected of terrorism, among them Mr. al-Nashiri, were subjected to brutal interrogation techniques developed by the CIA under what is euphemistically referred to as the Enhanced Interrogation Program or Enhanced Interrogation Techniques Program, and also to other forms of torture unauthorized even by this Enhanced Interrogation Techniques Program. Mr. al-Nashiri was captured in late October 2002 in Dubai. He was then transferred to CIA custody in Dubai by November 2002. Since his abduction, Mr. al-Nashiri was imprisoned in detention facilities in the following states. I am fortunate enough to be in a different position than Ms. Hollander and can actually name these states. First of all, Afghanistan, then Bangkok, Thailand, then Starekekuty, intelligence base in Poland, next Rabat in Morocco, then briefly to Guantanamo Bay military prison, from where he was flown to Bucharest in Romania, and then Antaviliai in Lithuania. From there, he was taken to Afghanistan, and as of the 6th of September 2006, Mr. al-Nashiri remains a prisoner in Guantanamo Bay military prison. All these states, including democracies such as Poland, Lithuania, Romania, and the United States, have the duty to effectively investigate these crimes. Yet, none have done so. This is why Mr. al-Nashiri welcomed and supported the prosecutor's request to authorize an investigation of the crimes committed in the context of the situation in Afghanistan and wanted very much to play a relevant role in this investigation. Mr. al-Nashiri is undeniably a victim of crimes which fall under this court's jurisdiction. He is still suffering from the consequences of these crimes today. He remains imprisoned in Guantanamo Bay without access to any effective remedy to seek justice for what happened to him since he was abducted in October 2002. The ICC has been established specifically for investigating and prosecuting situations like this one, to prosecute the most grievous crimes which no state wishes or is able to pursue. This court has been created also with the objective to give victims such as Mr. al-Nashiri greater recognition through the opportunity to fulfill the procedural aspect of their rights and freedoms by participating meaningfully in proceedings aimed at establishing the truth of what happened to them. To give victims such as Mr. al-Nashiri a voice in this process, to vindicate their rights by giving a public platform to their trauma, to their stories, and ultimately by providing the prospect of accountability of the perpetrators of these grievous crimes. The fulfillment of these rights in ICC proceedings requires the acknowledgement of Mr. al-Nashiri first as a victim, also as a party to the proceedings under Article 15, and of his legal standing and ability to appeal this specific impugned decision in this context. The pretrial chamber's decision effectively deprives this court of the possibility to exercise its jurisdiction over the crimes committed in the context of the situation in Afghanistan. As a result, the impugned decision deprives the victims of those crimes, including Mr. al-Nashiri, of their right to access justice, of all the procedural rights and possibilities that the Rome Statute intends for them to have. The possibility to participate in proceedings, to present their views and concerns, and ultimately to obtain redress and reparations if the perpetrators are identified, prosecuted, and convicted. But the first and sine qua non condition for any of these rights to become real and effective, not just illusory, is that this investigation is authorized. As regards the status of victims as parties under Article 15 proceedings and their right to appeal the pretrial chamber's decision, we fully support the arguments made in our earlier written joint filings and by our esteemed colleagues before the court today. I cannot, however, leave without comment one term used today by Mr. Guarilla on behalf of the Office of the Prosecutor. Mr. Guarilla used the term technical points to refer to the issue of the procedural standing of victims under Article 15 proceedings and the rights of victims as parties to appeal the impugned decision. This comment, this term, illustrates exactly why victims require separate representation and the individual right to submit appeals on their own behalf. What the Office of the Prosecutor refers to as a technical point lies at the heart of the interests and rights of victims. There is no issue less technical today from the perspective of victims, such as Mr. Abd al-Rahim al-Nashiri, whose very suffering is the reason why we are all here, why the Office of the Prosecutor indeed sought authorization for an investigation. It is this difference of optics that shows that the Office of the Prosecutor is not always in line with the justified interests of victims and in Article 15 proceedings. I would like to now present several comments on the irrelevance of the fact that the Rome Statute does not contain a provision which would explicitly state that victims have the right to appeal a decision of the pretrial chamber pursuant to Article 15, Section 4 of the statute. Giving victims even the widest range of rights in proceedings at a later stage before the International Criminal Court, while depriving them of the possibility of securing their rights at this stage, would make victim participation before the ICC illusory. There is no point in granting a wide range of rights if the victim does not have the possibility of appealing a decision which ends the case before it has even started. According to Article 21 of the statute, it is not only provisions of the court's core legal text, but also international treaties, recognized human rights under jus cogens, and relevant national state laws which should be taken into account in making a decision regarding victims' standing to appeal the impugned decision. Many of the criminal law jurisdictions in the world, including those relevant to this case, vest victims with rights in criminal proceedings. Most notably, Poland, Lithuania, and Romania all grant victims the right to appeal a decision in criminal proceedings which results in the refusal to open or close an investigation. The same principles underlie the creation of the ICC. I would like to focus in particular on human rights standards referred to in Article 21 of the statute. All human rights and fundamental freedoms enshrined in international law, treaties, and conventions, and recognized as jus cogens have a material and a procedural aspect. The crimes committed against Mr. al-Nashri constituted a violation of the substantive aspects of many of his rights and freedoms, including the right to life, personal safety and health, the prohibition of torture, his personal liberty, his fair trial rights, the right to respect of personal life and privacy, religious freedom, and most notably, the right to an effective remedy with respect to all of these violations. Each of these rights also has a procedural aspect which requires that effective legal and procedural mechanisms be in place to allow for protection against violations, and if the substantive violations have already occurred, that effective measures allow for redress, rehabilitation, and accountability. This must include access to an effective criminal investigation and an effective procedural remedy, such as an appeal against the decision not to investigate. The European Court of Human Rights has repeatedly stated, including in the case of Mr. al-Nashiri, that victims of violations of rights to life or the prohibition of torture have the right to a, I quote, thorough and effective investigation capable of leading to the identification and punishment of those responsible, and including effective access for the complainant to the investigatory procedure. Since none of the states which played a part in the crimes committed against Mr. al-Nashiri have conducted an effective investigation, some only creating a facade of an investigation, while others have outright refused to investigate, the procedural aspects of his rights and freedoms have not been respected. The vindication of these rights and freedoms requires that the ICC, acting within the boundaries of the complementarity principle, authorize the investigation. Now, where a decision entirely precludes an investigation by the court of last resort, such as this one, and when it does so contrary to victims' interests and based on interest of justice considerations, human rights law requires affording these victims standing to request review of such a decision and assert their rights through an appeal. In these proceedings under Article 15, in which victims, apart from submitting their representations, had no real ability to access proceedings up until the moment the impugned decision was issued, the only opportunity for them to materialize the right to, I quote again the European Court of Human Rights, a thorough and investigative and effective investigation capable of leading to the identification and punishment of those responsible, and including effective access to the investigatory procedure, is to appeal and to request a review of the impugned decision. Your Honours, I fully support the arguments made by my esteemed colleagues earlier today regarding the issue of jurisdiction, and will not repeat these arguments. I would just like to summarize that issue by saying that first, the decision is of a jurisdictional nature because it makes findings concerning the court's territorial, material, and temporal jurisdiction over the alleged crimes in the prosecutor's request. Secondly, the decision makes a determination on whether the court and the prosecutor may exercise jurisdiction over incidents and crimes referred to in the prosecutor's request. Mr. President, Your Honours, in conclusion, to my knowledge, this is the first time the International Criminal Court is put in a situation in which the pretrial chamber rejected the request to authorize an investigation at the proprio motu initiative of the prosecutor. This is the first time that such a decision of the pretrial chamber is based on a completely new assessment of interests of justice, inconsistent with the court's previous practice. This assessment of the interests of justice was conducted with complete disregard for the justified interests and views of victims who expressed support for the investigation. And this is the first time that, acting independently from the prosecutor, victims have requested a review of a decision by the pretrial chamber, rejecting the prosecutor's request to authorize an investigation. This is an opportunity for the court to acknowledge the trauma of Mr. al-Nashiri and other victims, to vindicate their rights and freedoms by allowing them to appeal. This is in line with the principles on which the International Criminal Court was established, to put an end to impunity for the most grievous crimes and to give recognition to the victims of these crimes. Thank you.
Thank you, Counsel. Counsel from the Office of the Public Counsel for Victims, you may now address The court, you 15 minutes starts now. Please
Thank you
proceed.
very much, Your Honor. Respectfully, in the conduct of the proceeding, my learned colleague representing the border, it's a very, very long name, sorry, should go first, but I will be ready to start if you consider changing the order. In the scheduling order, Your Honor, at page 5, you indicate that the cross-border victims should speak after legal representative of victims number 3, and that the Office of Public Counsel for Victims will immediately follow. Now, but if you consider changing the order, I'm ready to oblige.
Thank you, Counsel. Of course, we will keep the order. Then, if you are ready, please, the representative of the cross-border victims, you have the floor for 15 minutes.
Thank you very
Please
much.
proceed.
Thank
And
you very much.
excuse me for the misunderstanding.
Not at all. Thank you very much, Mr. President and Your Honours, and thank you very much to Ms. Masida for pointing that out. Mr. President, Your Honours, we appear today on behalf of a group of victims from Pakistan who we say are the victims of crimes within the jurisdiction of this court, the cross-border victims. In February 2014, the cross-border victims submitted a substantial dossier to the Office of the Prosecutor which contained clear evidence of serious crimes within the jurisdiction of the ICC committed in Pakistan but launched from Afghanistan. The evidence was gathered by two well-respected and highly regarded NGOs, Reprieve, based in the United Kingdom, and the Foundation for Human Rights, a Pakistani human rights NGO based in Islamabad. The evidence presented to the OTP and the human suffering detailed therein, no doubt like much of the evidence that this court considers day in, day out, is simply heartbreaking. If I may, I will very briefly highlight some of the most compelling aspects of that evidence. It is estimated that from 2004 to 2013, 2,500 to 3,500 people were killed in Pakistan as a result of aerial bombings launched from Afghanistan. Between 416 and 951 of those were civilians. In one incident alone in 2006, 81 civilians were killed in a single drone strike at a school in Chinagai. The Pakistan government recorded 80 children and one adult, presumably their teacher, as dead. We make submissions today on behalf of 32 victims from 8 separate drone strikes in which 73 civilians were killed or injured. They are, we respectfully submit, representative of many hundreds of other civilians in Pakistan killed or injured by cross-border airstrikes launched from Afghanistan into Pakistan. The dossier we provided to the OTP ran to around 300 pages, consisting of witness statements, NGO reports, press reports from reputable agencies, government documents including statistics prepared by the government of Pakistan, and detailed submissions on the legal basis for the jurisdiction of this court. We respectfully submit that the evidence gathered and provided to the OTP makes crystal clear that the requirements of Article 53(1) of the statute were satisfied. There was a reasonable basis to believe that crimes within the jurisdiction of the court had been committed. The case would be admissible under Article 17, and the gravity of the crimes and the interests of victims was such that an investigation would plainly be in the interests of justice. On the conclusion of negotiations on the statute for this court in Rome in July 1998, the late Kofi Annan, the then Secretary General of the United Nations, described the establishment of the International Criminal Court as a gift of hope for future generations and a giant step forward in the march towards universal human rights and the rule of law. To date, the victims we represent have been unable to secure any form of justice in any domestic jurisdiction around the world. This honourable court represents their best and in many ways their only hope of seeing justice done. So it is for that reason that we, on their behalf, humbly turn to the OTP and to this honourable appeals chamber in the hope of persuading you of the need for a full and proper investigation into the crimes we say they are the victim of. And we say persuade the OTP because despite having submitted such very detailed and comprehensive evidence to them in 2014, the OTP did not include or mention our victim clients in its November 2017 request for authorization from the pre-trial chamber. In our written submissions in this appeal, filed on the 15th of November of 2019, we expressed genuine gratitude on behalf of the cross-border victims to the OTP for its first public acknowledgement of them. On the 19th of July 2019, in its reply to our response to the OTP's request for leave to appeal, the OTP mentioned our clients in these terms. They stated that the interests of the cross-border victims are protected and that the Article 15.3 request for authorization was filed on the basis that it could potentially include allegations falling within its geographical, temporal or other material parameters, and this could potentially include the allegations by the cross-border victims if sufficiently grave, well-founded and within the jurisdiction of the court. Again, while generally grateful for this indication by the OTP, we respectfully submit on behalf of our victim clients that their situation perfectly illustrates, first, just why victims should, in and of their own right, be considered parties under Article 15 of the statute, and second, just why victims should, in and of their own right, be entitled to appeal pursuant to Article 15.4 of the statute. Because as I stand here today, it is still not clear what the OTP's attitude is as to whether it can, should, or indeed will investigate the crimes we say our clients are victim of. The OTP have only indicated that the crimes our clients have suffered potentially fall for consideration as part of the OTP's intended investigation, and then only if sufficiently grave. And in the same way that the OTP's attitude towards our victim clients is still unknown today, it was certainly not known at the time of the OTP request for authorization back in November 2017. And as a result, and by not including a substantial group of victims within that request for authorization, the OTP leave a multiple number of questions unanswered. Is it accepted that the crimes that they have sustained fall within the jurisdiction of this court? Is it accepted that the matter is admissible pursuant to Article 17? Is it accepted that the crimes are sufficiently grave? And do the OTP believe it to be in the interest of justice for the crimes to be investigated? Or perhaps more to the point, has the OTP concluded that an investigation would not serve the interests of justice pursuant to Article 53(1)(c)? By remaining silent about a particular category of victims, the OTP effectively deprives the pre-trial chamber from playing the supervisory role expressly contemplated by Article 15 of the statute. That situation is ameliorated to some extent by Article 15.3 of the statute, which, with the express provision that where the prosecutor has submitted a request for authorization, victims may make representations to the pre-trial chamber. We respectfully submit that one of the reasons why victims must be able to make such representations at the time of any request for authorization is to remedy and or address any shortcomings in the request for authorization. And that is precisely what the cross-border victims did in response to the OTP's November 2017 request for authorization. On the 31st of January 2018, the cross-border victims made submissions via the VPRS to the pretrial chamber, which asked the pretrial chamber to ask the prosecutor to confirm, one, whether the allegations had been considered, two, the OTP's position in respect of them, including three, whether the OTP had formed a view on whether the allegations fell inside or outside the jurisdiction of this court. The pretrial chamber was expressly asked to play a supervisory role by the cross-border victims. At paragraph 28 of the January 2018 submissions, we said, the self-evident reason for victims being able to make representations to the pretrial chamber under Article 15.3 must be so that the pretrial chamber can pass some comment on the scope of the prosecutor's request and her assessment of whether the victims are victims of crimes within the jurisdiction of this court. In order to perform this function and to assess whether the prosecutor has discharged her duties under Article 15, it is of course necessary for the prosecutor to explain her position adequately. And that is what we asked the pretrial chamber to address. So the cross-border victims made clear representations to the VPRS in the form of submissions to the pretrial chamber regarding their concerns about the adequacy of the OTP's request for authorization. Specifically, the OTP's failure to include details of the crimes they had sustained within their request. This, we respectfully submit, effectively made them a party to the proceedings before the pretrial chamber. And as a party to those proceedings, we respectfully say, unequivocally, the cross-border victims, like the OTP, were permitted to appeal as a party pursuant to Article 82(1). In the interest of time, we adopt and support the submissions made by other victim groups on whether a decision under Article 15.4 is a decision with respect to jurisdiction, but plainly issues of jurisdiction did arise via the submissions that we made to the pretrial chamber. So therefore, issues of jurisdiction plainly arose within the context of this case. We similarly adopt and support the submissions made on whether Article 21.3 or on internationally recognised human rights provides victims with a freestanding right to appeal. But what we do say, because of the OTP's failure to even acknowledge our victim clients, we respectfully say that their position is even starker, perhaps, than those of other victim groups, because they, unlike the other victims groups, have not got their interests being taken into account in any way, shape or form by the Office of the Prosecutor. As already prefaced in our written submissions of the 15th of November of this year, the cross-border victims received no communication.
Excuse me, Counsel, you have 3 minutes left.
I'm very grateful, thank you very much. The cross-border victims have received no communication or indication from the OTP, either publicly or privately, as to the OTP's attitude as to the material they have provided. And again, while grateful to the OTP for the OTP's indication that the crimes they have sustained might potentially fall within the scope of any investigation, the OTP, even as of today, has not indicated a definitive view as to whether or not the crime sustained by the cross-border victims will be investigated as part of any subsequent investigation if this appeal is successful. We say that cannot be right or fair. We are grateful to the legal representatives of the Afghan victims, Mr. Gaynor and Ms. Van Hooydonk, for drawing the Appeals Chamber's attention at paragraphs 42 to 43 in their consolidated response to the observations filed by the cross-border victims and Amici Curiae. They draw the Appeals Chamber's attention to the OTP's own strategic plan for 2019 to 2021. In that strategic plan, the OTP recognise, at paragraph 47, the need, and I quote, to effectively communicate with its stakeholders, with the victims and affected communities and the general public. The Office recognises the importance of timely and clear communications so as to maximise transparency and ensure that its stakeholders, including the victims and affected communities and the general public, have an accurate and up-to-date picture of the Office's actions and decisions, including the progress of its investigations and prosecutions when appropriate. For whatever reason, that did not occur with regards to our cross-border victims. Not only were they not referred to or included in the OTP's November 2017 request, but nor have they received any indication from the OTP as to whether it intends to pick up the cudgels and fight on their behalf. In the absence of any such indication, we respectfully submit that they must have standing with a clear right of appeal in and of their own right. Natural justice demands no more, but certainly no less. Thank you very much.
Thank you, Council, for your intervention. Then the Council from the Office of the Public Council of Victims, you have 15 minutes. Please proceed.
Thank you very much, Your Honor. Mr. President, Your Honors, the Office of Public Counsel for Victims appears today in these proceedings to represent the general interest of victims. We advocate for an interpretation of the court's legal framework that takes fully into account the right of victims to truth and justice and bridges any gap in the pursuit of accountability. Having filed extensive written submissions before both the pre-trial chamber and the appeals chamber, I shall focus today only on the key arguments arising from the question posed by the chamber. I will do so in an organic way rather than addressing the question sequentially. Starting with the question in Group A on the victim standing to bring an appeal under Article 82(1)(a) of the statute, Your Honours will recall the Office's long-standing position that in appropriate circumstances, victims may fall within the ambit of Article 82(1), as recalled in our submission number 93 at paragraph 28. The appeals chamber is only called at this juncture to rule on the victim standing to appeal in relation to the impugned decision or denying authorization to open an investigation pursuant to Article 15, paragraph 4. In our submission, the particular characteristics of Article 15 proceedings mean that the recognition of victims standing to appeal is justified and indeed required a fortiori in this particular context compared to other phases of criminal proceedings. In this respect, we concur with submissions advanced by other participants to the effect that Article 15 proceedings are exceptional in nature. This is clear from the special role and status vested in victims in the context of Article 15(4) proceedings by the statute, including the rights to make representations expressly recognized by Article 15, paragraph 3. The Court's legal framework clearly indicates that the role of those victims who engage with the Court by making representation does not cease once such representations are submitted. Rule 50, sub-rule 4 of the Rules of Procedure and Evidence empowers the pre-trial chamber to request additional information from any of the victims who have made representations, as well as from the prosecutor, and, if appropriate, to hold the hearing. Further, Rule 50, sub-rule 5, requires the pre-trial chamber to give notice of its authorization decision to victims who have made representations. Victims may therefore qualify as parties to those proceedings for all intents and purposes, justifying the recognition of a standing to appeal. It would be paradoxical for the statute and the rules to grant victims a specific place in proceedings under Article 15, paragraph 4, with an independent voice and role, but then deprive them of any recourse against decisions resulting from said proceedings, leaving them entirely dependent on the prosecutor's decision whether to file an appeal or not. In addition to the specific participatory rights granted to victims by the statute in the context of Article 15 proceeding, there are in our submission at least 3 other grounds rendering the present proceedings exceptional and therefore warranting the recognition of victims' standings to appeal in this context at the very least. First, proceedings under Article 15(4), such as the present one, do not involve any parties for the purpose of Article 82(1) other than the prosecution and the victims who made representation. The reference to either party in Article 82(1) should therefore be read as encompassing both. Second, the impact of decisions denying authorization on victims' rights is exceptionally significant, arguably more than any other decision adopted by this court. Indeed, the interest in seeing that the court is seized with a matter and that an investigation proceeds has been regarded as the most essential of all victims' interests. Decisions denying authorization preclude the opening of an entire investigation with dramatic and pervasive effects on the rights to truth, justice, and reparation of all victims of a potential situation. It is therefore particularly important to recognize the victim standing to appeal in this context. Third, in the present case, unlike other decisions adopted under Article 15, paragraph 4 to date, the pre-trial chamber's interpretation on the interest of victims formed a key element of the ratio decidendi of impugned decision. The pre-trial chamber denied authorizations on the basis that the anticipated challenges the investigator would face made it, as stated in paragraph 96 of impugned decision, and I quote, unlikely that personal investigation would result in meeting the objectives listed by victims favoring investigation or otherwise positively contributing to it, end of quote. In these very specific circumstances, it is fundamentally important for the victims who made representation under Article 15, paragraph 3, to be granted standing to challenge a decision purportedly adopted in pursuance of their interests, but effectively contrary to the representations they made. The Office and some of the Amici, in their written observations, submitted arguments to the effect that the recognition of victims standing to appeal would be in line with international human rights law and with internationally recognized rights to truth, justice, and reparation. I will not repeat the submission. Suffice it to mention that international human rights law provides that failure to carry out a prompt, impartial, and effective investigation amounts to violation of a victim's human rights. The European Court of Human Rights has consistently recognized that the possibility for victims, I quote, of appealing to a court against the investigating authority refusal to open criminal proceeding constitutes a substantial safeguard against the arbitrary exercise of power by the investigating authorities. The reference for the record is application number 59334/00, 18 January 2007, paragraph 139. The European Union Directive of Victim Rights of 2012 specifically provides in its Article 11 that victims of serious crimes be granted the right to a review of a decision not to prosecute, be it a decision taken by prosecutor or by investigative judges. The recognitions of a victim standing to appeal in the present proceedings would be consistent with international human rights law and with Article 21, paragraph 3 of the statute. It would also be in line with the general framework of the statute. We disagree with the OTP submissions that recognizing victim standings to appeal in this context would require a statutory amendment. The absence of a specific statutory procedure for victims to challenge a decision denying authorization is not per se determinative. For instance, as already recalled, the absence of a dedicated provision in the statute empowering affected states to appeal decision under Article 87(7) did not preclude the appeal chamber from entertaining the appeal filed by Jordan in the al-Bashir case. Further, while the general principle of victims' participation in the proceeding are enshrined in the statute, the modalities of implementation of said rights have largely been left for jurisprudential development. From a jurisprudence perspective, I would like to note the evolving practice before this court and before other international fora, pointing towards the increased recognition of victims' prerogatives and participatory rights in the context of international criminal proceeding, including on appeal. It was recalled also by Ms. Hurst early this morning. This appeal chamber has also been increasingly willing to entertain appeals from entities other than those traditionally considered as parties under 82(1) of the statute. Recognizing the victim standing to appeal in the present circumstances will be fully consistent with these developments. As a final note on this topic before I rapidly turn to issues on Group B, I would posit, Your Honors, that victims in the present proceeding should not be penalized to the novel nature of issues currently before the court and the uncertainties surrounding their prerogative in the present exceptional circumstances. The Chamber has been prepared in the past to take exceptional measures in similarly novel circumstances to ensure that victims are not unfairly deprived of an opportunity to participate for reasons beyond their control. Therefore, should the victim standing to appeal in the present proceedings not be recognized, I would respectfully invite the Chamber to nevertheless consider and rule on the arguments put forward by victims pursuant to its broad discretion as well as its general powers under Rule 93.
You have 3 minutes left.
How many?
3.
Moving on to Group B questions, the issue of jurisdiction. The reference to jurisdiction in Article 82(1)(a) covers not only the existence of jurisdiction pursuant to Articles 5 and 11 of the statute, but also the exercise of such jurisdiction regulated by Article 12 and 13 of the statute. As recently noted by Judge Ebo Ezuji in the context of the Comoro proceedings, whenever a decision, and I quote, has as its outcome an equal potential than not that the court may not exercise jurisdiction, it should then be beyond dispute that such a decision is a decision with respect to jurisdiction within the meaning of Article 82(1)(a), end of quote. For Article 82(1)(a) to apply, the operative part of a decision itself must pertain directly to a question on the jurisdiction of a court, encompassing, in our submission, the existence or exercise of such jurisdiction. Against this background, we submit that the impugned decision is indeed one with respect to jurisdiction. The pre-trial chamber's key finding concerned the absence of a reasonable base to proceed with an investigation under Article 15.4 based on the interest of justice. The impugned decision is a ruling that the court may not exercise its jurisdiction over the proposed situation. And I will recall for the time, paragraph 19 of Judge Ebo Ozuji dissenting opinion in the Comoros appeal. It's our submission that the impugned decision as a whole is to be considered a determination with respect to jurisdiction subject to appeal pursuant to Article 82(1)(a). Your Honors will recall that appearing before the pre-trial chamber, we supported the prosecution request for leave to appeal. This was the case because that was, at the time, the procedural avenue chosen by the prosecution for challenging the impugned decision in the circumstances. However, we insist that we are facing an issue of jurisdiction appellable under Article 82(1)(a), and that a fortiori, I will take only 30 seconds, Your Honor.
Thank you very much. Please conclude.
Thank you. And that a fortiori, the impugned appeal also, the issue subject to appeal also fulfill the requirements set out in Article 82(1)(d). The four subparagraph of Article 82(1) are not necessarily alternative or mutually exclusive. Nothing in the preparatory works states as such. The wording of Article 82(1) confirms in our submission this reading, which is also consistent with the object and purpose of the provision. Finally, Your Honor, I would like to draw the attention of the Chamber on the fact that two issues certified for appeal by the pre-trial chamber do not fully cover the issues raised by the legal representative in their respective appeal. However, the appeal chamber has inherent powers to consider arguments that are intrinsically linked to the issues on appeal and clarify or amend issues certified for appeal by the relevant chamber a quo. Consequently, we respectfully invite the chamber to consider all arguments put forward in this important appeal, regardless of its conclusion on the appropriate legal basis for appeal. Thank you.
Thank you, Mr. Masida. We will now adjourn for 1 hour lunch break and resume at 2 p.m. At 2 p.m., at which time we'll hear observation of the Amici Courier.
All right.